Welcome. I'm Paul Hitchcock and really excited for my two guests here today. Got Thomas Tomasevic, who is an incredible Vistage Chair in the Seattle area, doing some amazing things. Going to hear about what he's doing with his groups there and in Hawaii. Also got Harry Barth, who is the founder and senior managing partner of Barth Calderon. This is our headquarter office there, Orange County, California. Harry is in high demand for his talks across the country to many incredible groups. He's a Vistage member, Vistage speaker, and a lot of other business groups across the country. And this is a very hot topic on the Corporate Transparency Act. I encourage everybody to type in your questions here as we go along. And Thomas, if you could, monitor that as the questions come in at the end, Thomas will handle the Q&A. There's a lot of misinformation going around, so we want to clarify all that. But let's first start. Thomas, tell us what you're doing with Vistage. What are you focused on there?
So thank you for asking, Paul. So good to see Harry again. What I do is I'm a Vistage chair, which means that I work with executives, mostly CEOs, in my regions, in regions I cover. So I cover Seattle and Honolulu. And so I have two groups in each area that essentially we work to make sure that things like Transparency Act is fully understood, that the new law is fully understood, that taxation issues, business conditions, what to do, how to do it is fully understood. So in other words, my objective is to make sure that these groups of CEOs have the support system, not to be alone and not to be left without any advisement or help, so that they can help each other. These are peer groups. So in other words, we kind of flourish together better. And that's the mantra behind what I do. I have about 60 people in my groups, as I said, 4 groups, and we meet monthly. We have one-on-ones all the time. And so it will be interesting for them to see today's presentation. It will be interesting for them to understand who qualifies, who doesn't qualify, why do we have the TCA, etc. So there's many questions that I'd like to have answered, and I'm looking forward to having Harry tell us more about it.
Great. Now, I want to tell everybody as we get into Harry here that we are going to send the replay out to everybody as a follow-up with contact information for both Thomas and Harry. And if you want to get one-on-one with Harry and the team, if you have any follow-up questions personally pertaining to your situation on the Corporate Transparency Act, happy to get you one-on-one. And I know, Thomas, you have a complimentary strategy session you offer as well. People can learn about your groups, the CEOs in your group, and what you're doing. So, great. Harry, what do we need to know here?
Okay, I'll take it away. So, Paul, Tom, it's great to see everybody. Let's talk a little bit about this wonderful Corporate Transparency Act. So, first of all, let me give a definition that we all need to know. I'm going to be using the term FinCEN quite a bit throughout my talk with you guys this morning. And FinCEN means the Financial Crimes Enforcement Network. And the Financial Crimes Enforcement Network is the subdivision of the United States Department of Treasury and is the agency that is responsible for the implementation and enforcement of the Corporate Transparency Act. The Corporate Transparency Act was passed by bipartisan legislation in 2021, was deferred for 2022, 23, and came on in full force in January 1st, 2024. And what it is, it's the building, and I repeat, of a private, for governmental use only, database, and it's important to understand this, of who is behind the businesses in America, who's behind the LLCs, the limited partnerships, the corporations. So it's important to know that the hunt for is identifying the human being. So if we have Blue Ocean LLC, who owns it? Who are the human beings and who they are? Why is it done? Well, since 9/11, the government's been trying very, very hard, not Western governments and modern Eastern governments, to help prevent terrorist financing, to money laundering and tax evasion. So this is a law enforcement database that is being built, and it applies, unless there are exemptions, which we'll go over in a little while, it applies to all, not just new, but all pre-existing and all new limited liability companies, limited partnerships, and corporations. So if it is an entity that was born through the Secretary of State's office in Washington or Hawaii or any place else in the country, it is an entity that more likely than not, unless it's accepted, must comply with the Corporate Transparency Act. So I always get questions, is the government serious about this? And the answer is absolutely yes. And let's talk about the fines for failure to comply. So if we don't comply by the due dates, and we'll talk about the due dates in a few minutes, it's a $591 a day fine for every day that we're not in compliance with no cap. And that's per violation. So if we have 4 entities that are not in compliance, it's $591 a day for each entity with no cap on the number of days. It's going to be enforced by the Department of Treasury through the IRS. Lovely people. And in addition, there is a criminal component. So if we are willfully saying, hey, I'm not going to comply with that thing, it's a $10,000 criminal fine and up to 2 years in jail. It's a felony. So are they serious? Yes, they are. Are there challenges to the Corporate Transparency Act? Yes, there are. There was a challenge by the National Small Business Association versus Yellen in the Northern District of Alabama, basically, and a case, I think it's a Boyle versus Yellen in Maine, where the challenge is out as to whether or not it's constitutional. In the Alabama case, the issue is whether or not Congress had the power to pass the Corporate Transparency Act. So it's a constitutional question whether they had the power. The judge in that case ruled that it was not constitutional, but it was in summary judgment. And just for everybody's edification, the government has already appealed that. And based upon my close to 50 years of experience, I think the government's appeal is going to be successful and that judge will be overruled. And it only applied, just so you know, to members of the National Small Business Association. Everybody else still has to comply. The other one, which is just getting underway in Maine, challenges the fact that the regulation of businesses belongs in the states and not to the federal government. And we'll see where that challenge goes. I expect it to go about the same place as the National Small Business Association. I don't expect any circuit courts of appeal or Supreme Court to do away with the Corporate Transparency Act. It has a noble purpose. I think that there are some components of the Corporate Transparency Act that we'll talk about today that might not be constitutional, that may need some repair, but inherently, no. So who's impacted? Well, the best guesstimate, the number of businesses that are pre-existing January 1st, 2024 that need to comply are 33 million. And those 33 million businesses, limited partnerships, limited liability companies, and corporations that are not exempt have to comply by December 31st, 2024, by the end of this year. If they're not in compliance, the $591 a day fine begins. For new entities, Tom, formed after January 1st, 2024, from the date that the Secretary of State's office says you are born, all right, we have 90 days from that point. So the ones that were born in early January, they're due now to come into compliance with the Corporate Transparency Act. Then we'll talk about what compliance is in a moment. But let's talk about who is exempt from the Corporate Transparency Act. It's very important, and it affects your demographic quite significantly, Tom. So let's take a look at who's exempt. So anyone that is a public company, members of the New York, shares traded on New York Stock Exchange, American Stock Exchange, NASDAQ, they don't need to comply. Understand that it's where the terrorist activities happen. It's in Sally and Mabel's hair salon that might be a Washington S corporation. It's in the back room where the cartel is operating. They're not operating in Microsoft. So large public companies, and not only that, they're under SEC regulation. We know who the officers are. We know who the directors are. They're fingerprinted, background checked, and everything else. They have to be in order to get listed on the exchange. So we know who they are. They're not required. Then also SEC registered investment advisors, venture capital fund advisors, also for the same reasons. They're either regulated significantly by the states or regulated by the SEC. We know who they are. So they've already been through vetted. They don't have to comply. highly regulated financial institutions, trust companies, not trusts now. Trusts themselves, as you notice, I said LLCs, limited partnerships, corporations. Trusts are not born in the Secretary of State's office. So trusts themselves do not have to comply with the Corporate Transparency Act. But you will learn in a few minutes if the trust holds an entity that has to comply, then the trust needs to comply. And that's where the complexity begins. So, but trust companies, banks, credit unions, registered securities brokers and dealers, for all the same reasons, they're highly regulated. We know who the people are, they're exempt. Public accounting firms that are registered under the Sarbanes-Oxley Act, same reason. We know who they are, they don't need to comply. Nonprofit organizations, surprisingly, don't need to comply. And that's really surprising. It doesn't make any sense. Political organizations, of course, and subsidiaries of exempt organizations are also exempt. So if the organization is exempt, a subsidiary of that organization is exempt. And we'll explain that in a minute, that's especially with Vistage groups. It's baby companies, not parent and children. I mean, not brothers and sisters. And I'll explain that carefully. But then there's the one big exemption that applies to most of your constituency, Tom. And let's talk about that exemption. It's called the large company exemption. Now, what I'm going to give you is an and, not an or. Okay, you got to have all three in order to be exempt. You have to have 20 or more full-time employees. All right. Not contract employees, not part-time employees. 20 is defined by state law, full-time employees. And your offices must be headquartered in the United States of America. And you must have $5 million or more of gross sales. So if you have those three components, you're an exempt entity from filing under the Corporate Transparency Act. Remember, it's for the small company. This is targeted to small businesses. So let's use Barth Calderon as an example, my law firm that I own. And do we have over 20 employees? Yes. Do we have our offices in the United States? Yes. And do we have over $5 million of gross sales? Yes. So Barth Calderon is an exempt entity. But Harry has 12 other entities, just like your Vistage members do, that hold my real estate. I have 3 pieces of real estate and 3 separate LLCs. I hold intellectual property. I have other companies that I own. I have investments in an LLC. All the stuff we spoke about when we spoke to your groups over the years, I have them. So I have 12 entities that have to be registered under the Corporate Transparency Act, but the mothership itself does not have to be registered. Of course, if we drop down below 20 employees or below $5 million of gross sales, we have 90 days then to register that entity under the CTA. Okay. So what we're going to do, Tom, to bring this really to life and help people understand, you and I are going to form a new entity in Washington. All right. We'll call it a Tom and Harry Co. LLC. And we're going to, of course, what we're going to manufacture, we'll manufacture widgets because we all manufacture widgets. And we have 2 DBAs. Widgets are us and widgets are them. All right. So we don't have 20 employees. We're forming a new company. We don't have 5 million of gross sales. Our headquarters are in Seattle. So that entity must file under the Corporate Transparency Act. Also very important to note is that it is the entity, the required entity, that'll be responsible for all the other transactions that fall under the Act. Not Harry or Tom, but our entity. And I'll explain that in a moment. It's critical. So Tom and Harry, we go to, we'll say on April 10th, we file with the Secretary of State, and Tom and Harry Co. is LLC is born. We now have 90 days to bring that into compliance, or we don't willfully, crime, don't do it. Don't do it negligently, $591 a day fine. All right. So what do we have to do to register a company? Well, we have to go to the FinCEN website. Everything has to be done electronically. And we have to register the company. What do we have to do to register our company? So we have to give it its name, Tom Harry Co. LLC. We have to, all of our DBAs have to be given. Widgets are us, widgets are them. Then we have to give the physical address of our company, not the lawyer's office where it was formed, not the accountant's office, not a UPS suite, not a post office box, the physical address of our company. If we are a virtual company working from home, our home address needs to go on that document. And we must submit a unique identifying number, which in our case will be our EIN number that we got from the IRS when you and I formed, when they had the attorney form the company for us. Now, if we formed a single member LLC, which is tax disregarded, it'll be our social security number, which we need to use, or a EIN number that we got as a matter of convenience. So that forms our company with CTA. Now, that is just the beginning, and you'll see why the 33 million turns to 200 million in a moment. So now, once our company is formed, we now have to report another term, BOI, beneficial owners of interest. Anyone that owns 25% or more of our company must register as a BOI, beneficial owner of interest, with FinCEN. So in our particular case, Tom, it's you and me, kid. All right. So Tom Tomasevic turns around and says, I own 50%. Here is my name. Here is my home address. You need to give them your home address. And here is a uploaded PDF copy of my unexpired driver's license or unexpired passport. That is the requirement for Tom, who's greater than a 25% owner of our LLC. Same thing for Harry. Now, one of the things that might be of interest or a little trick, so to speak, is Tom, if you go, and something you should do, you go to the FinCEN website, something we can't do for you, and open up an account over there. And Paul will put up in the chat the FinCEN, www.fincen.gov website. And in the account, they'll want to, where do you go to high school, where do you go to elementary school, what was the color of your first dog, all that stuff, and two-factor authentication. And if you request to open an account with FinCEN under the Corporate Transparency Act, you give them that information, your name, your address, and the identifying documents. They will issue you, Tom, a identifying number. So it'll be, number blah, 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 blah. And then every time you have to put Tom Tomasevic as a required identifier under FinCEN, you just put your name and number. They already have your information. So we don't have to, every time you do something, put your home address publicly and your identifying documents. And again, I want to repeat for our audience that the database is not a public database. This is closed. This is for law enforcement use only. We get that question over and over again in the Q&As. All right, so now you and I are registered. Okay, but which is not clear under the Act, we also must register everybody who has any significant control. It's not just ownership, it's also control. So let's say that you and I, in our widget company, we hire Paul Coe, all right, to be the manager of our LLC. You and I are going to kind of be passive. We invested the capital, and Paul Coe is going to run our LLC and manufacture or control that. Paul Coe has no ownership interest in Tom Harry Co. None. But Paul is the manager. We appointed the manager, so they control Paul Harry Co. So now Paul Co. becomes a reporting entity. So we have to report in that corporation, because he's a corporation. Who's the president? Reports. The CEO reports. The COO reports. The CFO reports. And if the board of directors of Paul Co. can replace the C-suite members, then every member of the board of directors must report. Ugh. All right. So, and we could do the same thing. Someone can have a 1% ownership interest and be the manager of our LLC. Someone could be the general partner of our limited partnership. Someone could be the president of our company, has no ownership interest in our company, in our corporation, but they're reporting because they have substantial control. Now, it's very important to understand that the determination of ownership is one thing, all right? and 25% or more has to report. Under 25%, no. And if they're a minor, they don't have to report, Tom. But the parents have to report. But when they reach the age 18, then they got to report. But it's also important to understand that the determination of substantial control is a legal determination. It's not just black and white. In some cases, it's easy. In some cases, it ain't so easy looking at the reporting. Now, Tom, I've spoke to your groups. We've talked about asset protection. We've talked about estate planning, all of those issues. And as you know, I'm a licensed attorney in Washington. And we had suggested, Tom, you don't hold your 50% interest in your own name because then it's going to wind up going to probate, a surrogate's court. So we want to put it in your living revocable trust. So now Tom's living revocable trust, Tomasevic Family Trust, now owns a 50% interest in a reporting company. So now the trust as the owner must report as well. So now the creators of the trust, Tom and spouse, need to report. The trustees of the trust need to report. The trust protectors need to report. The investment trustees need to report. If it's a directed trust, the directed director needs to report. If someone holds a power of appointment inside the trust to switch around beneficiaries or move assets around, they need to report. And that is also a very significant and highly technical legal determination. So as you could see from our company, we can have 40 reporting requirements. So we turn around and I spoke to one of your colleagues. I spoke to several of your colleagues in Texas, and we've used Texas as an example. And Vistage Chairs in Texas, and all their members they're all the oil and gas business. They're all in the oil and gas business. So they said, let's run that through, and this will kind of give us a bit of the lunacy associated with this. They said, hey, look, when we drill an oil well in Texas, it's a risky business. They blow out, people get hurt, there's potential pollution problems. There's lots of risk associated with drilling an oil well. So every single oil well that's drilled, large company, small company, is done in an LLC for asset protection purposes. All right. So we create that LLC. That, of course, is a reporting entity. So we need to report that LLC. He says, now, the people that drill that oil well, who invest in that oil well, and usually 4 or 5 investors, don't do it as individuals. They form an LLC for the purpose of making their investment, also to protect against liability. So we might have 4 LLCs who are the investors in there. So every one of those 4 LLCs, its owners and its controllers need to report on this one oil well LLC. Now, traditionally, Tom, you and I, if we were doing that, we're not going to do one oil well. We may have 15 oil wells. So we usually have a holding company, and each holding company has the single member LLC that's a member in that oil well. That holding company has to report, and usually our holding company is held in our trust, whether it be our family trust, in a dynasty trust, in a gifting trust for our children, in an asset protection trust, or any one of many significant asset protection or estate planning trusts. All of the characteristics of those highly technical trusts also must report. And there are absolutely no exceptions, meaning you can't be 90% complete. We have to be 100% complete, or FinCEN is not allowed to accept our filing. We can't say, hey, we got 90% of it, 10% to go. Rejected, $591 fee. I think that's going to get modified and changed, and that part is a little bit unconstitutional and might have to get changed. It's just too onerous. But like they say in infomercials, Tom, there's still more. So for entities, to Tom and Harry's entity that got formed after January 1st, 2024, this doesn't apply to the previous entities. There's another filing persons called the company applicant. So the paralegal, so let's say we used my law firm to do this, and my paralegal, Cheyenne, was the one that filed the necessary papers in the state of Washington. So since she was the filing person needs to report. So Cheyenne needs to report that her name, address, number, needs to report filing. And if I'm the attorney that told and supervised her, the supervising attorney must report as well. So, ugh, this is the reporting for every new entity within 90 days in the United States of America, unless there is an exception. Now, in looking at this, when we're forming new entities, it's not quite as scary because we know the entity, we know who the owners are when we formed it, we know if we're going to put it in a trust, we know who has substantial control when we form that entity, and we know who the company applicants are. So what it did do is it drives up the cost where it would have cost you a couple $1,000s to form an LLC. Now it's going to cost you $2,400 because there's more work that was placed upon us. Just to make the record clear, the AICPA, the American Association of Certified Public Accountants, has told all of their members, which is pretty much all the CPAs across America, not to touch the CTA with a 25-foot pole because it would be considered the unauthorized practice of law. So, because determining substantial control and trying to figure out the trust holdings or the holding companies that are involved takes a highly skilled, some of it easy, it is easy, but some of it's highly complicated and the penalties are high. And I would think you'd want to do that, whether it's us or somebody else, under attorney-client privilege because of there's criminal penalties associated with it to get it done. So it puts an undue burden on small business in America. Now, for the 33 million pre-existing entities that we have until December 31st, 24. So let's talk about that date, for example. There is another piece of legislation moving through Congress right now. It passed the House, has not yet passed the Senate, and not yet signed by good old Joe, that makes some modifications to the Corporate Transparency Act. So, few good, one bad. So the first modification is a delay from the December 31st, 24, December 31st, 25 for the pre-existing entities, which would be wonderful relief, because I don't know how anyone's going to get 33 million entities through by December 31st, 2024. I don't even think it's possible. Second, that they have is that right now there's a change. So Tom, if you move from Washington to Hawaii, for example, you now have a Hawaii driver's license, new address in Hawaii, you only have 30 days from the time that your number filing with FinCEN, that you got that account, you got that number for Tom, to make those modifications, or $591 a day fine. So that's the legislation extends that to 90 days for changes, which would also be welcome. But the draconian aspect of that piece of legislation, in language which makes it even difficult for us lawyers to understand, basically reiterates and instructs FinCEN, the Financial Crimes Enforcement Network, that unless a registration is 100% complete, they cannot accept it. No exceptions. Very difficult. So what does that mean? So let's say we want to add Paul as a member of Tom Harry Co. So make a Tom Harry Paul Co. And we're going to make, you'll own a third, Tom, Harry will own a third, Paul will own a third. And so we cut a business deal, and Paul turns around and says, I'm not, that's a bunch of bunk that's going on with the government. A lot of good things, you have my capital, you have my investment, but I'm not going to comply with the CTA. So that causes our organization not to be able to file or go out of compliance. We now have a third owner that's not registered under the CTA. So what do? Well, allegedly, we're supposed to point the finger at Paul and turn him in, and then he could be held criminally liable for causing our organization to be in non-compliance and causing us to pay $591 a day. Ugh. So what else has to change? So what has to change is that when we formed our new LLC, Tom Harry Co., we now, in our operating agreement or in our limited partnership agreement or in our corporate shareholders agreement, have a new section called Corporate Transparency Act, where we say that all of our members agree to be a member of Tom Harry Co. If you are a reporting person, have over 25%, you must report and you agree to report. If you do not report, we will throw you out, give you back your investment at book value, and goodbye. All right. And if you are a member of our company and you refuse to comply, we will throw you out because you cannot be a member unless you comply. So every new entity form needs to have Corporate Transparency Act language. But that also takes us to the 33 million pre-existing ones. Now, in the 33 million pre-existing ones, Tom, that we have until December 31st this year to file, the company applicant component, the attorney, the paralegal, is not required. That's only for new entities after 2024. For the old entities that we have, we don't need that. But all the rest we do need. This can be a cluster, you know what? Why? Because we got to figure out over the entire, it could be 40 years ago, who the beneficial owners are. People have died. Things have moved through probate. Things have moved through trust administration. There have been divorces. There have been stuff gone to minors. The minors have become adults. There are divorces. People don't even know where the hell they live anymore. And we have that. And when we look at documents, when we look at your members' documents and others, and we look at the shareholders' agreements, the bylaws, we look at the operating agreements, limited part, they're usually woefully out of date. They haven't been kept up to date. Transactions have happened in entity ownership over the years, for a multitude of reasons that have to be ferreted out. And then those interests are usually held in some form of a trust. And then you got to analyze the whole trust to figure out who's reporting in there. And so you can have 20, 30, 40 reporting transactions on a single pre-existing company. And we see that all the time. Lately, we've been going back, and a company didn't make the 20, it doesn't have 20, it may have 100 million gross sales, but they're doing it with 12, 13 people. They're a high-tech company. They do IP, the licensing IP. They have a continuing software as a service model. They don't have that many employees, but they sure as hell have large amount of gross. They still got to comply. So the opportunity here is to take this as an opportunity to review all the governance documents of the entities and bring them up to speed. This is a really important thing. It helps for asset protection. It helps for estate planning. And this is I got to report anyway. It's a good time to get everything up to speed. So that also requires, I would believe, that in everybody's pre-existing governing documents, that we put language into those, amend them and put language governing the CTA, because we, Tom, you and I, are responsible for all of our owners and our controllers. That we have to make sure that when Paul moves to another state, that he's in compliance, so we don't go out of compliance. So that's a good opportunity for that. Another good thing, if there's a good thing, Tom, this is one and done. Once we filed, it's not an annual reporting requirement. It is strictly one time. We have to report changes under current law within 30 days, but it's not a reporting. It's not. We don't have to file every year. Once we get it done, absent changes, we're done. One of the other issues that I'm of concern is cybersecurity, and you'll even see this on the FinCEN website. A lot of very sensitive information is going to be flying around, and it only can fly around by law electronically. So you have all this sentiment that's being transmitted to law firms to FinCENs, meaning we got to make sure we have secure vaults and portals, got to make sure that data is encrypted from end to end, because scammers are all over the place trying to intercept that information. And there's going to be a log jam of that information as people may wait a little longer till the end of the year to see if they need to file. And then it won't be, I can tell you they will not be able to file in time, and properly, and they will wind up in filing deficiency territory. And when the enforcement starts, a whole hell's going to break loose $591 a day goes real fast. 10 days, $5,900, 4 entities, $20,000, and the IRS, with it just no. So we really need to get it done. The purpose of the act is noble. We all want to be safer, but let me give you my legal opinion for what it's worth, based on all my experience, is that this act puts a significant burden on small business. Although it costs nothing to file at FinCEN itself, it's going to cost money. It's going to cost money because it's costing an entity being formed is going to cost more, because more for us to do. Every pre-existing entity needs to be analyzed. Who's going to be able to analyze that? Laypersons, business people are not going to be able to interpret the estate planning documents, the asset protection documents, the control issues. They're going to have to seek out professional help, or should seek out professional help. That's going to cost money. For example, in our firm, we're giving our clients a bargain, and for other potential new clients, we'll analyze an old company for $595, not even an hour of attorney's time. And then you got to file it. So I could just see you, Tom, sitting on a Sunday on the FinCEN website, putting in 50 or 60 entries for all your entities or more, that you'll pull your hair out of your head if we have any left anyway. All right. And nuts. So we do have a service for $250 that will file 100% of everything for people with FinCEN. We'll do it for you. So, but it's a cost. It's time and cost. It places a burden on small business in America. But the real question is, will it solve the problem? I do not think so. I do not think this will end terrorist financing. I do not think this will end more Panama Papers and Pandora Papers. I don't think that this will solve the problem. They'll create new individuals under AI. Criminals will find a way around. Terrorist financing, money laundering, and tax evasion will continue, probably at the same level, but American business is now going to be burdened significantly. But let me talk about American business. If it's a foreign company, if they have to register their business in the United States, if they're coming into Washington, they're going to do business in Washington, a Chinese company, they've got to file for the American entity with the ownership and control. And sometimes that's not going to be so easy to figure out the ownership and control in China. All right, it becomes literally, the word is magnificent, enormous. So you're facing a mountain to get that done.
And Harry, we have questions too.
We're going to get to all the questions in a sec. So I think that everyone has a picture now of what this is about, and we need to take it seriously. We need to get it done. I would not wait, because I think it's here to stay. I mean, you got a notary, you got to put down your address, your driver's license, fingerprint. I mean, it's here to stay. This information is here. The cause is noble. So maybe a few things will be modified, but I think the CTA is here to stay. So I think it's a really good time to let's start taking questions and see if I can answer as many of them as I possibly can.
Thomas, do you want to field some of those that are showing up there?
Sure. So there is a question: do all of the board of directors need to be reported individually?
Yes.
Right.
If the board of directors has control, so here's the question. If the board of directors can remove and replace the C-suite members, president, CEO, which they usually can, then the board of directors needs to report individually. You bet.
Got it. So understood. So independent of the percentage of ownership, if any.
Right, because it's a control factor. So the control factor is independent of percentage ownership. You can have Tom, you could be completely passive in our company. You do nothing. Well, they're just an owner. In non-voting, 50% interest you have to report. And Paul can have a 1% voting interest, and so he needs to report. Or not even have a voting interest in our company. He just has to have substantial control. He has to report. It's control, ownership, and control. They're driving behind who can move money around. Remember what they're after. Who are the human beings who own and control these small businesses? Because we hear that there's a cascade of 18 companies. You see it, you watch FBI on Tuesday night, you'll see, they got 15 shell companies all around. That's exactly what they're after because that's where the activity takes place.
So when it comes down to requirements, it's and when it comes down to exception, it's or. So in other words, the higher largest combination. Next question. I have an LLC that includes 2 members from India. Our holding company is in India. We are considering dissolving that LLC. If we do that before 12/31/24, do we need to comply?
No.
So
you just need any it's a good opportunity. It's a great question because many of us have companies that we have formed. Probably you did the same thing, Tom. We've formed an LLC. If you never really used it, we formed an LLC for some business venture that never went forward. We have it sitting on the shelf. That's a complying entity that has to comply. So if we dissolve them before the end of the year, they do not need to comply. And also the 20 employees, the gross sales as at the time of filing.
Got it. So in other words, most likely case for most of the Vistage members is any LLC they wholly own that is under 5 million and not 20 employees. Any entity in their trusts that has controlling authority. Exceptions are few in Vistage community. In other words, over 5 million, over 20 employees, and what was the last one?
It's just the headquarters in the United States.
Correct, headquarters in the United States, which is basically all of them. So in other words, really, we have probably about 50% of all of the Vistage members that will have to comply to this thing, and they have an option to try to do it themselves. And if it's too complex, reach out to people like you. So just to make sure that I understood it, you had a special deal for your existing.
Well, I have a special deal, period, for Vistage members as well, where we will analyze their pre-existing company for $595 and file it for $250.
Got it. I see. So analysis is 600 and reporting is 250 plus.
Correct.
Understood. Thank you. Excellent. Well, so this is probably going to get me to present this thing to my Vistage members, and I may have to come back with some extraordinary questions because complexities will abound.
Yeah, it's if you just keep in mind the goal. Who are the humans behind the veil? The law enforcement wants to know who that is, and they're building that database. Assuming that they're allowed to build a database, it's not unconstitutional. We all need to do it. We're doing it anyway. It's the Patriot Act, know your client, notaries. We're doing it every day that we can't get a loan. They gotta know who the hell you are. You can't just put down the entity. So it's not odd, not strange. What I don't like is the egregious draconian fines and criminal penalties. You don't even have that for a tax return. So, but here it is, I guess, because it's building a law enforcement database.
Who collects the money? Is it the IRS?
IRS
charge with collecting money. Yeah.
IRS. Yeah. Lovely.
Yeah. And then they hire just about 20,000 more IRS agents.
Yeah. They're going to enforce the Corporate Transparency Act. But it's FinCEN. These are the same people, Tom, that enforce the foreign bank account requirements. This is called the FinCEN reports. If you have more than $10,000 in a foreign bank account, by law, you can go to jail if you don't report that. It's just reporting. There's no cost to report other than if they have help getting it done. It's just something that we need to do. So with that, if we have no other questions, any other questions, Paul? Remember,
no, we're good. I just
one other thing. Somebody dies. You have a probate administration or trust administration. So it's when they give us a little break here, Tom. It's when it goes from the administrative stage into the hands of the beneficiary. If that beneficiary has over 25%, then the beneficiary needs to report. But during the interim period of time, we kind of get a break.
Got it.
Great information. Thank you, Thomas, very much.
Tom,
thanks, Harry.
great to see you, buddy.
Likewise.
All right, Paul, thank you. Take care, guys.
See ya.
Bye.
you like